Now moving on to Roman numeral 2 of the outline, we will talk about several issues, beginning first with lease break versus lease termination. And the reason that I pointed this out in the outline is I think there is some confusion among some of the management companies and landlords in Virginia as, one, the difference between the two, and then sometimes they're asking for both, which is not appropriate. The way it typically works is that if you enter into a lease agreement, you as a tenant, and you've entered into a lease agreement with a landlord, the tenant is going to be obligated for the full term of that lease, even if they breach and are evicted. They're going to remain statutorily obligated for the remaining term of that lease or until a new lease takes effect, whichever first occurs, with the landlord having a duty to mitigate. Now, let's put that in plain English. If a landlord and tenant enter into a 12-month lease agreement, let's say starting on January 1 of 2017, and let's say on June 1, the tenant gets into default for non-payment of rent, and by July 1, that tenant is evicted for non-payment. So the landlord has now retaken possession of the leased premises, and the landlord obtained a judgment for non-payment of June's rent, and now again has an order of possession. Well, the tenant, even though the tenant has now lost his or her right to possession as of July 1, the tenant will nonetheless remain obligated for the remaining term of that lease. So from July and through December of 2017, that tenant is going to owe the landlord the remaining rental obligation due under the lease agreement, even though they have been evicted and dispossessed of possession of the leased premises. Now, what the General Assembly, or to balance the playing field, what the General Assembly did a number of years ago is place a duty to mitigate on the landlord, such that the landlord cannot sit on his or her hands knowing that they have the evicted tenant on the lease for the remaining term. They have to mitigate the damages. In other words, they've got to get the unit back on the market and try to get it re-rented. And to keep with my example, let's say the landlord is successful in getting the leased premises re-rented as of September 1 of 2017. That means that the evicted tenant would owe the landlord for July and August, but their duty would then terminate once the new lease took effect September 1. And the landlord would have complied with their duty to mitigate the damages and have successfully re-rented the apartment, and so that cuts off the obligation. So again, the ground rule is that the tenant remains obligated on the lease for the remaining term of the lease or until a new lease takes effect, whichever first occurs, with the landlord having the duty to mitigate. Now, with that as a backdrop, where you go next is you have a situation where, again, my example, a 12-month lease beginning January 1 of 2017, expiring December 31st, 2017, and you have a tenant who comes to you, and this isn't a military situation where you have statutes that would allow the tenant relief if they're being deployed elsewhere or being transferred. But you have someone, let's say, you have someone who's got a job and has now lost that job, or they've been transferred. Maybe that's a better way of giving the example. So they come to you on June 1 of 2017 and tell you that they've now been transferred to Ohio, for example. Now, what that means is, again, they're going to remain obligated on the lease or until a new lease takes effect, whichever first occurs, with the landlord having a duty to mitigate. Now, some of my clients, what they will do is they will have what's called a lease break fee. And what that means is that if the outgoing tenant who's being transferred in my example agrees to pay 60 days worth of rent, 2 months worth of rent as a lease break fee, then their obligation due under the lease terminates as of that point. So in other words, if you go ahead and pay us 2 months worth of rent right now, then we will terminate any further financial obligations due and owing under the lease, and you're free to go. Now, that is enforceable as long as that's an arm's length negotiated bargain, if you will, and there's risk borne on both sides, because let's say the landlord accepts the 2 months as a lease break fee, but is unable to re-rent the apartment until October. Well, now the landlord lost, because the tenant comes to them June 1, and pays and is given a release from the lease in exchange for 2 months worth of rent. So the landlord's got June and July in my example covered. Come August, if they haven't got anybody in there, now the landlord's losing money. And in my example, if they don't get it re-rented until October, then they've lost several months worth of rent. On the other hand, let's say that the tenant pays the 2 months in June and leaves, and the landlord is able to get the apartment re-rented come July. Well, then the landlord wins, because now they got 2 months worth of rent paid and they were able to get it re-rented within a month. And you might say, well, isn't that collecting double rent? Well, typically in Virginia, you're not permitted to collect double rent, but here again is a negotiated buyout, and risks are being borne by both parties. So if you take 2 months worth of rent as a negotiated buyout and you release the tenant from the remaining terms, financial obligations due under the lease, now it's a race against the clock. If you're able to re-rent the apartment within 2 months, then the landlord wins. If you're not able to re-rent the apartment within 2 months, then the tenant wins. But that is a permitted negotiated buyout of the lease. Now, where people fall down is I explained to you the traditional statutory way of the tenant remaining obligated until a new lease takes effect, or until the end of the term, whichever first occurs, or this lease buyout. Where some people fall down is that they will require a lease buyout fee of 2 months, for example, and still hold the tenant responsible for the remaining term of the lease or until a new lease takes effect, whichever first occurs. That is not enforceable because you're double dipping there. So your options are really two. You can either hold them to the statutory framework that I just explained, or you can negotiate a buyout which would reduce their potential exposure to an amount that both parties can live with, and that's a settlement and early termination of the lease. I bring that to your attention. A number of folks are doing that, the lease buyout, for example, but just make sure that if you do the lease buyout, that once that amount, that agreed upon amount has been paid, that ends the obligation. Don't continue to hold them responsible and take a fee on top of it. That's not going to work.